Well, and welcome to tonight's live stream. If you did not get a chance to watch today's trial for the Karen Read trial, you absolutely missed something huge. But don't worry, I've got the very best excerpts from the whole day for you. We're going to be going over those tonight. We knew it was going to be a blistering cross-examination of Trooper Proctor, the lead detective on the case against Karen Read. We knew that, and it absolutely did not disappoint. It was powerful. It was thorough. I'll say it was overwhelming cross-examination of Trooper Proctor. Now, does this mean the Commonwealth automatically loses, Karen Read automatically wins? No, it doesn't mean that at all. But it does give the jurors a lot of room to find reasonable doubt. It gives them a lot of room to question the investigation that took place, to question the motives of the people who were doing the investigation. And that's what made it so powerful on behalf of the defense. So we're going to break that down, and we're going to be talking about what exactly happened today. You're going to see the excerpts, like I said. You're going to really be amazed at all the things that happened today. So I personally have never, text messages, of course, are huge in any case, or potentially huge, because they can reveal some things that people didn't know, didn't think would ever be revealed. I don't know, though, that I have ever seen text messages bring someone down more than in this particular case. Now, today's testimony was hours and hours long, so I have boiled it down to the absolute best moments of the day so that we can, and I've got about 20 minutes, and that gives us plenty of time to talk in between about what the significance is, why it matters, and some of those questions. And at the end, we'll take questions, Q&A at the end. One thing I do want to go ahead and say up front, there was language in there in what was said today, Trooper Proctor's own words, and so I've gone ahead and used that. In some cases, a couple of cases I deleted because I just was not wanting to put that on this channel. I just didn't want to. But to some extent, some of that has to come across because it's part of the integrity of what happened and what Trooper Proctor himself said. It's relevant. So we've got some of that. I'd ask you not to use those words again in the chat. That creates a lot of work for Marlon and mamapinks to try to cull through that and pull it all out. So our moderators do such a great job, and I want to give them all the kudos. Marlon and mamapinks are fantastic. And so please help them do their job by not using some of those words. They're in the original, and that's just the way it's going to be. But I'd appreciate you're not adding to it. Don't be Trooper Proctor here. So let's start with the text to the high school buddies. And first, before I do that, even let me say hello to the first 5 who were in the chat tonight, which is Mystic One, Michael Lalonde, DJ, Loves My Angel One, now revealed as Sue. Welcome, Sue, and Hopester. So, and be sure to hit the like button and subscribe, and then we will just dive in. The very first set of text messages that he covered today were text messages that John O'Keefe, and let's just do a simple what happened in case there's any question about it. Karen Read is accused, she's a defendant, she's accused of several things, including second-degree murder. And the Commonwealth of Massachusetts says she ran into her boyfriend, hit him with her car, and left him to die in the cold and the snow, and he died the next morning. Karen Read's defense team says that's not at all what happened. She was dropping him off at a party at a Boston police officer's home. He went into that party. Excuse me. They beat him up. He came back, and they are the ones who brought him out and dumped him in the snow to die. That's what they have to say on the defense side. So on that very first day, the lead detective in the case, Trooper Proctor, has been charged with heading up this case. It's John O'Keefe died that morning, and the body was found that morning. John O'Keefe was declared dead that morning. But Trooper Proctor is texting with some of his buddies, not just one, not just like a best friend, which would be questionable enough, but he is actually texting with 9 people, 9 close high school friends in a group text. And he's talking details about the investigation. And that's just the tip of the iceberg. What he says about Karen Reed, about her personally, about her medical conditions is absolutely appalling. I mean, it's truly astonishingly improper. It's hard to come up with adjectives that sort of talk through this. But one of the things that came out early was the lawyer for Karen Reed, Alan Jackson, said, "You never thought that these would ever become public, did you?" And he said, "No." I thought, what an understatement, because wow, there is just a lot. So let's go ahead and get started. And these are, as I said, the highlights of the day.
The homeowner's going to get some shit for this. Answer
in the text messages.
Next text. He's a Boston.
And let me go ahead and back up, give a little bit more. So this is the friend saying the homeowner's going to get some shit. And then Trooper Proctor is saying no.
Cop 2. That doesn't sound like an explanation for your nope.
So he said,
no,
nope,
just
he's
saying
a Boston
he's a
cop
Boston
too.
cop as well. Mr. O'Keefe is a Boston cop.
And that's why he's not going to get any shit. Correct, Trooper Proctor?
Well, he's not going to receive any shit, sir, because he had Mr. Albert, the homeowner, had nothing to do with Mr. O'Keefe's death.
And you knew this 16 hours into your investigation.
Yes.
Less than a day.
Yes.
To your satisfaction.
To my satisfaction and to the members of my unit.
So let him finish. We didn't get the finish your answer.
To my satisfaction and to all the members of my unit who investigated that day.
Objection. Calls for speculation.
So I'm going to let it stand.
So we started off the day with, or early on anyway, Trooper Proctor going through these text messages, and in them, he says that already he is barely into the investigations. This is still the day, and trust me, Karen Reed's team will get to this, but this is the very day that John O'Keefe's body was discovered, and he's already saying that the homeowner will face no shit, will face no trouble because of what has occurred. And he's only 16 hours into the investigation, and he's already comfortable enough with that opinion that he's telling 9 friends who are not police officers, who are high school friends, he's telling them that. And Karen Reed's team will drive that point home
Then
next.
a person with the phone number 0095 wrote, "I thought he was drunk. Did he get beat up?" You see that?
I do.
And you wrote, "Nope." Is that right?
Correct.
Yet again, this is before 11 o'clock at night on January 29th, 2022, some 16 hours into your investigation. Is that right?
Yes.
So before you ever went to the crime scene, before you ever went into the house, only having interviewed 3 folks, you had this case nice and wrapped up, didn't you?
Yes. Based on the evidence my office uncovered that day, the 1 shoot discovered at the scene, the 1 shoot at the hospital, Mr. O'Keefe's injuries, the broken taillight pieces underneath the snow.
Trooper Proctor, I didn't ask for an explanation. I asked, did you, in your mind, have this case wrapped up? Was it cut and dry in your mind?
Yes.
That in and of itself is an absolutely huge, staggering admission, because the investigation has barely begun, and the trooper says he has already formed an opinion that this case was wrapped up. And the point, of course, for Karen Reed's team is from that moment on, the investigation changes. There's no longer a reason for him to look in every nook and cranny to find possible evidence against the people in the home, because he already knows who did it. Now his task, Karen Reed's team is saying, is to move forward with proving Karen Reed did it, not to move forward with finding the truth. And I want to say thanks to Glenda Kildow for gifting a lawyerly membership. Thank you. I appreciate that very much. And Kayla is enjoying the live stream. I'm so glad. She's been a member for 3 months. Thank you, Kayla. That's like full time. We've only just now hit 3 months. We were kind of late getting started on memberships, which was my fault. So let's keep going.
As a matter of fact, both you and Sergeant Buchanan believed that he had suffered the injuries as a result of a physical altercation based on information you received from the paramedics initially, correct?
Initially, we didn't know what we had. We knew there was some significant injuries to Mr. O'Keefe. And we're still figuring out how those injuries occurred.
Well, you just testified. Initially, we didn't know what we had.
Right.
But 16 hours after the fact, you wrote the following sentence. That's what I initially thought after talking to Canton paramedics. Correct?
Correct.
So initially, you did think you knew what you had. A physical altercation leading to a death. Correct?
Correct.
You were aware, initially, not a single broken bone, correct?
Not that I was aware of.
Not a single fracture, correct?
Not that I was aware of.
Not a single bruise below the neck, right?
Not that I observed.
All of those are really important points for Karen Reed's team, because they're saying that from the beginning, the initial thought was this was someone who had been beaten up. The injuries he had looked like that. And they even heard that from EMTs who were on the scene. So that was initially what Trooper Proctor and Sergeant Buchanan believed. They thought that John O'Keefe had been beaten up. The irony of that is that's still what Karen Reed's team is arguing. They're still arguing that is exactly what happened. You had that initial opinion and it was right. Why did you abandon it so quickly after just 16 hours without having talked to many of the people who had important information? And they're saying, if you look at the body at John O'Keefe, Karen Reed's team is arguing he didn't have broken bones or fractures anywhere. He didn't have bruising below the neck. And that, they suggest, would have happened if he had been hit by a car. The only way he would only be beaten about the head is if somebody was intentionally attacking him. And may I say, there were scratches on the arms too, which were very important in terms of what Karen Reed's theory is. She believes that a dog inside the home also was involved in the attack. So let's keep going through. Oh, and let me put Mama Pinks. Now, Mama Pinks is one of our mods, and she is making the point, now that Proctor's testified, it makes sense why the prosecution didn't originally have him on their witness list. And she is appalled at Trooper Proctor, who believes he's disgusting and an embarrassment. So Trooper Proctor, from the beginning, there was huge speculation. Normally, you might have the lead detective come early and often during the case. They would come initially to sort of lay out the land for people. How exactly, what were the things that you did to investigate? What were the things you found? This was someone who was there from the beginning throughout the entire process. So, of course, he would have relevant and important information. But in this particular case, he didn't come. Weeks into trial. This is day 23 of trial. And we had yet to have seen Trooper Proctor on the stand. Now, as Mama Pinks pointed out, we know exactly why. We did not have access to all of these text messages. We knew a couple of little tidbits from it, from the defense opening statement, but we had no idea about the quantity of things that he said that were very, very harmful to the prosecution. And I want to thank Jen Ken for gifting 10 lawyerly memberships. Thank you so much. We have a brand new emoji, which I'm sure we have unlocked by now, that Marlon created for us. So I can't wait to put that up. I'm a little slow on that. So my apologies, but we ought to be able to have it up and able to use tomorrow. We will be doing an extra live stream tomorrow night at 7 p.m. because there will be testimony tomorrow. So just so you know. Okay, let's keep going through the trial.
5051 writes.
And when he says that, the number, there isn't necessarily a name associated with it, but this is one of the numbers that texted in that group text of 9 buddies of Proctor's.
Assume you guys are out to make it cut and dry since it involves cops, correct?
Yes.
And Bird writes, something stinks, correct?
Correct.
And then Trooper Proctor, you responded, yeah, but there will be some serious charges brought on the girl. Isn't that right?
That's right.
Who did you mean by the girl, by the way?
The defendant.
Karen Reed?
Yes, sir.
The defense point, we are 16 hours into the investigation, and Trooper Proctor has already decided that there will be, quote, serious charges brought on the girl. Karen Reed, already known to him. And it sounds as if he's talked it over with people back at the department, with people who are higher up than he is. They all are certain that there will be charges against Karen Reed. Karen Reed says there was a whole lot more examination and investigation that should have been done. You hadn't even barely started with what you should have done. Now, we're going to get to some of the things I mentioned at the beginning. I would ask, there's some language that's used by Trooper Proctor and that gets read here by the cross-examination by Karen Reed's lawyer. So I'd ask you not to use that in the chat, and that saves Marlon and Mama Pink some trouble.
And he writes, she hot at least, correct?
Yes.
And what was your response to that?
From all accounts, he didn't do a thing wrong. She's a whack job.
C word.
But
That's
sir,
me.
you didn't have
I added that.
all accounts, did you? From all accounts, he didn't do a thing wrong. That was your decision 16 hours into the investigation, correct?
Yes.
And the other decision that you made and the other determination you came to was my client, Karen Reed, was a whack job.
C word.
Right?
Yes.
What else did you say in response to she's hot at least? Or she hot at least, question mark.
So following that text, I responded, yeah, she's a babe. Weird Fall River accent, though. No ass.
So just in case you have the same, I listened to that several times before I could hear it, and it took AI translating it for me to really be able to understand it. He said weird Fall River accent, though, just in case you're wondering. At least that's how AI interpreted it. And after listening to it, I think that made sense.
Yeah, she's a babe. Who's the she?
Miss Reed.
Weird Fall River accent, though. You talking about her, the way she talks?
The accent.
And no ass. Now you're talking about her body, her physique, correct?
Yes.
You think that's appropriate?
Absolutely not.
And then 5051 says, oh, she's skating, right?
Correct.
And what did you write after that?
My response was zero chance she skated.
And then what did you write?
She's fucked.
17 hours into this investigation, Trooper Proctor, you made the decision that you were going to put it on Miss Reed, didn't you? Put the case on Miss Reed. She was going to catch the case, correct?
No, absolutely not.
And then Bird decides to chime in. Good, no ass bitch, right?
Yes, that's what he wrote.
And how did you respond to Bird saying, good, no ass bitch?
I laughed.
Thought that was funny, did you? Trooper Proctor? Thought that was funny?
It was unprofessional of me.
So it's just astonishing that just 16 hours afterwards, he's talking to people who are not from law enforcement and using language like that to describe the person he believes committed a murder, and is saying, without question, this person is not going to skate. This zero chance. This is just barely into the investigation, same day, and he feels comfortable enough with that he's telling people who are not even involved in law enforcement, and laughing at some of the comments. He's talking about her physically and about her appearance. And believe it or not, it is going to get even more offensive.
And then you write, what?
She's got a leaky balloon knot.
Trooper Proctor, explain to the jurors what a balloon knot is.
Your essentially, I guess, your rectum area.
Your anus?
Yes.
That's what you were referring to about Miss Reed?
Yes.
and you were making fun of her because you believed at that time that it leaked? That's how you were treating Miss Reed? Yes or no?
Yes.
You followed that up with the phrase leaks poo, didn't you?
I did.
Again, another reference to Miss Reed's medical issues and medical conditions, correct?
Correct.
Specifically focused on her anus, correct?
In reference, yes.
Were you aware at the time that you wrote this that Miss Reed had suffered a colectomy surgery, very serious surgery?
I was not, sir, no.
Were you aware that she had had 10 surgeries in 18 months, several years prior? 10.
I was not aware of that.
Notice that this information about her prior surgeries normally wouldn't come into trial. It wouldn't be something the defense might want the jury to hear this for sympathy purposes, but it normally would be irrelevant and it wouldn't be admitted in. But all of that came in thanks to the statements by Trooper Proctor. I don't even know what he could possibly have been thinking to talk about someone like this. Clearly, this was medical information that he had privy to because he had interviewed her or because he was on. I don't even know how he managed to get this information, but he's sharing it with people who are not involved in law enforcement, who have no need to know her private health information. And truthfully, it's hard to even know what to say about this because his words are just so astonishing. I just can't believe that a police officer is talking about her this way. And I would not be at all surprised if the jury wasn't pretty appalled too. Now, that's what he had to say about Karen Reed. The cross-examination also covered some of the things he had testified to or said that were, in the defense opinion, untrue. One of the things that was most important is they believe that Trooper Proctor covered up his relationship with the Alberts. The Alberts were a family. Some of the Alberts lived inside that home. Brian, Nicole, and their children lived inside the home where John O'Keefe was found in the yard. They were the ones having the after party. Karen dropped her boyfriend, John O'Keefe, off. He was going to go into the house. The people inside the house, who were mostly relatives, except for a couple of friends, they all agree John O'Keefe did not come into the house. That would suggest Karen Reed killed him with her car in the front yard before he ever got into the house. That's not what Karen Reed says. And now her attorney is going to point out that the lead investigator, Trooper Proctor, had a relationship with the family of the people inside the home. His relationship was with the brother of the person who owned the home, Chris Albert, brother to Brian Albert, who owned the home.
Did you testify under oath, same oath you took here today, in a former proceeding in February of 2024, that you did not know and did not have any relationship with members of the Albert and McCabe families?
Now, the McCabes were also related. They were also inside the home at the party. Jennifer and Matt McCabe were at the home inside the party. Jennifer was Nicole Albert's sister, so still related, just not on the Albert side.
Did you? You told First Assistant Beeland that you didn't know, didn't have a relationships with
Objection, Your Honor.
members of the Albert and McCabe families. Answer, correct.
Yes, that's correct.
On or around January 29th, 2022, you were close enough friends with Julie Albert that she had your personal cell phone in her cell phone, correct?
Julie Albert is married to Chris Albert, brother, Brian Albert, who owns the home.
And vice versa.
I wouldn't classify us as close friends at all.
Okay, let me get back to my question. Did you have her cell phone in your phone, and did she have yours?
I can't recall if I believe I had her stored in my phone.
10 days before Mr. O'Keefe's death, you were texting with your sister about whether Julie Albert might be available to babysit for your own son, correct?
Yes.
And then you personally interviewed Julie Albert and Chris Albert in this case on February 10th, 2022.
Sergeant Buchanan and I did, yes.
And you didn't mention a thing about your relationship with Julie Albert, Chris Albert, or Colin Albert
Their son.
in any report that you ever drafted in this case, did you?
I did not.
Not one word, correct?
No, sir.
You received after your interview, you received a phone call from Julie Albert about 6:17, about 45 minutes after you began the interview and then left, correct?
Yes.
6:21, you called her back and you spoke for 3 minutes and 58 seconds. Is that right?
Yes.
Did you discuss the interview?
I don't recall the contents of that conversation.
So they're just cataloging all of the ways that he had a relationship with Julie Albert and with the Albert family in a broader sense. Part of the reason why Julie and Chris are important, even though they weren't at the party and even though they weren't the owners of the home where John O'Keefe was found, is because their son was present at the house earlier in the evening, perhaps later in the evening, but certainly earlier in the evening. And one of the reasons that matters is because Karen Reed's team says their son, 18 at the time, I believe, had a feud, would be a better way to put it, a feud with John O'Keefe. He may be the one, Karen Reed's team believes, who beat up John O'Keefe, who attacked John O'Keefe inside the home. He may be the one that the Alberts are circling the wagons, that the police are protecting. That's one of the things they've argued. So they go through just a list of connections between the two. And they talk about the fact that Nicole Albert was a possible babysitter for them. They'd actually talked about that. They talked about the fact that they had each other's cell phone numbers in their cell phones. She talked about the fact that that the relationship was not something that Trooper Proctor told anybody about. And then he interviewed them. He was actually the person who interviewed them, even though he previously knew them, and said nothing to anybody about that. And then as soon as the interview was over, she called him and talked to him personally. It was not noted in what he wrote in his report, but I assume it was able to be told based on the call records from his phone. And then there's another issue of the relationship with Julie Albert. Let's keep going.
About Julie, and she said, when this is all over, she wants to get you a thank you gift.
So this is,
and I respond,
a little more context. This is Trooper Proctor testified that probably his best friend in the world was his sister, Courtney. Courtney was very close friends with Julie Albert and her sister. And so Julie Albert, what they're talking about here is the gift that Courtney, the sister, writes to Trooper Proctor and says, Julie Albert wants to give you a gift. A very strange comment in the middle of an investigation.
Get Elizabeth one.
Hang on just a second. Let's take them one at a time. You were asked about this on direct examination by Mr. Lally, right?
Correct.
And you looked at the jurors, paused, and said, I never asked for a gift. I never received a gift. Elizabeth never asked for a gift. She never received a gift. You remember that?
Correct.
You said you never asked for a gift, correct?
Correct.
What's your next text?
Get Elizabeth one.
Get Elizabeth one what?
Referring to a gift.
Right. So you did, in fact, ask for a gift, didn't you?
For my wife, who had been home with my children for the last 10 nights.
From Julie Albert?
Yes.
For your participation on this case?
I don't know if that's, yes.
So this gift, although never given, that's such a very bizarre thing for a witness to say, hey, I would like to give you, policeman, investigator, detective, I'd like to give you a gift. It just seems improper. It seems like some kind of payment for who knows what, better treatment, I assume. It certainly would have been wildly improper. And one of the things that the prosecution suggested when Trooper Proctor was on direct examination was Trooper Proctor, as the defense pointed out, looked straight at the jury and said, no, I didn't ask for a gift. It wasn't my idea. I never got one. And the defense is pointing out, well, you did say when get Elizabeth one, get my wife one, and the suggestion that maybe he wanted a gift from them. So that's what the defense is trying to argue based on this testimony. I have some more people to thank. Let's start with Jersey Jen. Thank you for gifting 5 lawyerly memberships. You have to enable your ability to receive the gift of a membership, and Mama Pinks will put in the chat exactly how you do that. I want to thank Zero Patience for the super sticker. Thank you very much. And Lisa P gifted 5 lawyerly memberships. I appreciate that very much. Kayla, thank you. We've got Susan Costello has a super sticker, and I really appreciate that very much. And Stephanie Lawrence as well. And I will save the rest. And there's a question in there, so we'll get to those toward the end. We've got some more testimony to go through. One of the questions they asked about was another witness we covered here on the channel, another witness who testified earlier, Brian Higgins. He was present at the party. Whether or not he overlapped with John O'Keefe is, of course, depends on who you were talking to. He was at the bars drinking with them all before this after party at the Albert home. Brian Higgins is an ATF agent, and he's a close friend of the Alberts and particularly of Brian Albert. So let's hear what the cross-examination.
Personally interviewed Mr. Higgins, correct? He was a colleague of yours, correct?
He worked in a different agency, yes.
You knew he had this flirtatious relationship with Karen Reed, is that right?
Yes.
You became aware that he ignored, you saw the text messages, you became aware that Karen Reed actually ignored text messages from Mr. Higgins while at the Waterfall Bar and Grill with John O'Keefe, correct?
Yes.
You were aware that at 2:20 a.m., Brian Higgins sent a text message to John O'Keefe prompting him to go to 34 Fairview, correct?
I don't recall that text.
Do you recall a text from Brian Higgins to John O'Keefe after they left Waterfall? Where are you at?
I don't recall that one either.
And literally in the minutes before John O'Keefe's death, you saw video surveillance of Brian Higgins and Brian Albert taking fighting stances with one another, correct?
I interpreted that as horsing around.
And you decided not to image his phone, is that right?
Correct.
You didn't ask for consent to search his phone or to take his phone, correct?
No.
You didn't seek a search warrant to get his phone, is that right?
No, sir.
Did you know that on January 29th at 2:22 a.m., there was a call between him and Brian Albert that morning?
I was not aware of that.
So that's a really huge thing for him not to be aware of, because that phone call, and in fact, there were two, there was a brief call and then a call back. And the defense believes Brian Higgins may have had a motive to kill John O'Keefe. John O'Keefe and Karen Reed were living together, boyfriend, girlfriend, and they came to Brian Higgins had been having a sort of hidden background relationship with Karen Reed. It hadn't really gone anywhere, but she had flirted with him. He had flirted with her. They'd sent each other those text messages that we covered a few days ago. And we'd also seen that Karen Reed, according to him, had kissed him. And that was even discussed in their text messages. All of that might have given him a reason, the defense says, to want to kill John O'Keefe so he could get together with Karen Reed, because he might have believed that John O'Keefe was the reason she was blowing him off. She wasn't interested in him or involved in him or responding back to him after initial interest. So he may be the one, they think, who possibly killed John O'Keefe. At a minimum, they say he should have been considered a suspect, that in that first 16 hours to have decided everything before you've even talked to Brian Higgins is way too fast, way too inappropriate. One of the next topics related to the medical examiner. In this particular case, the medical examiner, after looking at the body, doing the autopsy, concluded that the manner of death for John O'Keefe was undetermined. She would not mark it as homicide. Obviously, that's pretty important for the jury, because if the medical examiner couldn't even tell, how can they tell for sure that it's homicide? Now, there are ways that they certainly can legally that might not be true medically. Those are two totally different standards, but you'll see the way this sort of develops and unfolds here at trial.
The medical examiner notified you on April 28th, 2022, that the manner of death, in her words, could not be determined. Is that right?
Yes.
she would not rule, at least in terms of the manner of death, would not rule this a homicide. Is that right?
That's correct.
Do you see a text message received from Trooper DeChico with a photograph of the autopsy report?
Yes.
And that autopsy report indicates undetermined. Is that right?
For manner, yes.
What was your response?
Of course, it's undetermined.
And then what else did you write?
She was a whack job.
Sort of a theme here, right? Any of the women that he disagrees with them become whack jobs. That's what he called Karen Reed as well.
Trooper DeChico texted you, rookie move, not going into a meeting with the ME and getting that homicide determination, correct?
Yes. It's him busting my chops and joking with me.
Because you see it as your job, you and Trooper DeChico, to go in and get the homicide determination. That's your job, right?
Not at all, sir.
You responded, Yuri and I, who's Yuri?
Sergeant Buchanan.
Yuri and I had 2 conference calls with her, sent her numerous photos, etc. We laid out the entire case for her. That was your response, correct?
Yes.
You were explaining
So he's saying we did all we could.
how much effort you went to try to get her to change your opinion to homicide, right?
Objection.
No, not at all.
DeChico then responds, not good enough. Should have had me and Jeff do it, right?
Yes, that was his response.
Busting your chops that you didn't meet the standard of getting her to change her mind to make it a homicide, right? That's what he was that's what he was busting your chops about.
We would never try to change the mind of a medical examiner.
On February 1st, 2024, you were asked, so what you're telling this grand jury today, and you expect this grand jury to believe that you didn't care whether the medical examiner came back with a homicide determination? It doesn't matter to you? And your answer, quote, no, because either way, Ms. Reed was going to be charged. Right?
Correct.
Playing into the defense point. The defense point is they were going to charge Karen Reed, and it didn't really matter what facts got in the way. It didn't really matter if the medical examiner said she couldn't determine if it was homicide. It didn't matter if there were other potential suspects. It didn't matter if Brian Higgins had a motive. It didn't matter if Colin Albert maybe had a motive. It didn't matter if they were present. None of that mattered because Karen Reed was going to get charged come hell or high water. That's the defense argument. And what this witness told the grand jury was because it didn't matter what the medical examiner said, because either way, Miss Reed was going to be charged. And he said, correct. That is extremely important for the defense. So that's exactly the point that they're trying to make. So let me thank a few more people while we are at it. I can't remember if I thanked Stephanie twice, but thank you again if it's twice, but thank you. I appreciate the lawyerly membership gifted by Betty. And Cindy Griffin asks about the basement floor of the home being redone. I've seen that rumor on the internet. All I know to do is go with the testimony that's been presented in the trial, and there was no testimony about that. Is that a surprise? Not at all, because of the fact that they did not go into the home and they did not do any kind of investigation inside the home. They didn't consider it a crime scene. So there's nothing that's been done to sort of find that out. As a result, we don't have evidence about that. And I think that's really all we can go with. Anne Marie, I appreciate the super sticker. And Kia, I appreciate that super sticker as well. Thank you. Mama Pinks is giving us the directions to receive the gift membership. Thank you, Mama Pinks. So click the join button, the top right-hand corner, click the 3 dots, click the gift settings, slide the button to turn on gifting, because we have a lot of gifts that have been given. It'd be appalling if people didn't collect them. So hopefully if you're interested in that, you can turn that on, and we'd love to have you as a member here on the channel. Okay, let's keep listening to testimony.
You signed numerous affidavits under oath, claiming that you did not seize Ms. Reed's vehicle until 5:30 p.m. on January 29, 2022, right?
Correct.
At the time that you seized Ms. Reed's vehicle, you were unaware that there was alarm.com surveillance footage of the area from which the car was seized, correct?
Correct.
The fact of the matter is, that was false. The car was not seized at 5:30, was it?
4:16 p.m.
Right. An hour and change, an hour and 18 minutes, hour and 20 minutes earlier. Is that right?
Yes. There was just an incorrect transcription of time.
An incorrect
This is so good. Really listen to this. This is such good cross-examination right
transcription
here.
of the time. Would you
Yes.
call that, I don't know, a Scrivener's error?
Objection.
Ask it differently.
Sure. Was it a typo?
Yes.
It was a typo. So you got the 4 wrong, you got the 1 wrong, and you got the 6 wrong. And those turned into 5 and 3 and 0, right?
They were typos, sir.
Okay. Fact of the matter is, you delivered that car to Canton PD, to the Sallyport garage, before a single piece of taillight material was ever found in this case, Trooper Proctor. Is that correct?
Correct.
And that
So why does that matter? It's because one of the most important pieces of evidence in the entire case is the taillight on Karen Reed's car. The prosecution says the reason the taillight on the back passenger side of the car was broken is because she ran into John O'Keefe. When she knocked him down, the force of that broke the taillight on the back of her car, leaving pieces of the taillight at the scene. It took them multiple times, multiple visits out, it was the middle of a blizzard, to find all of the pieces. And the prosecution says the reason for that is the snow was melting. So snow was coming down. They found a few that first day, but not until after 5:30. And then they found some on 3 successive days. And the reason that they were still finding pieces was because the snow was melting. And so they finally could see them. So in this case, the Karen Reed's team believes that the taillight was cracked barely. And she did point that out to people that morning, but that it wasn't significantly broken. That instead, what happened was Trooper Proctor, perhaps other troopers, broke the taillight further and then took pieces to the scene and scattered them. Not really clear why they did that more than once, but did it on more than one occasion. And then those pieces were going to be the evidence to set up Karen Reed. They weren't actually found there. And one of the arguments the prosecution had made is that's impossible because we were finding pieces at the scene before we even collected your car. So how would we have done that? How would we have taken those pieces and planted them there? So what the defense is doing here is showing that that story didn't jive. Once they were able to determine the exact time that the car was picked up and impounded, they know now that the police had it before any of the pieces of taillight were discovered. And furthermore, that the place where they were taking it, the Sallyport, I cut this piece out just to try to make it shorter, was only 2 or 3 minutes away from the scene where John O'Keefe's body was found. So Karen Reed's team is trying to say there's enough time for the troopers to plant this evidence at the home of the Alberts where John O'Keefe's body was found.
video is missing the precise time that vehicle was delivered.
And let me give a little intro rather than just throw you into this. We covered this last Friday and then this weekend in videos that Sallyport video that was of Karen Reed's car being pulled into the Canton police station and left there. They put crime scene tape around it and so they could inspect it later. It was impounded. This is the day that John O'Keefe's body was found, that he was found lying in the snow and then at the hospital declared dead. So the video shows the vehicle, her SUV, Karen Reed's SUV, being pulled into the Sallyport garage at the front of the police station. But what the video showed when we saw it from the prosecution was inverted. It was a mirror image, so that we were seeing the opposite. So we were told, look at the rear passenger side, which we thought we were looking at, but it turned out it was the other side. The defense then pointed out in cross-examination of the witness that it had been inverted and that everybody should be looking at the opposite side, which in fact, a bunch of people were around that. The question in everybody's mind was, could the troopers have been breaking the taillight? Could that possibly have been happening? And so that became extremely controversial. So now he's talking about this Sally Port video with this witness, and there was a real bombshell surprise.
To the Sally Port, correct? Did you note that the time jumps from 5:08 to about 5:50 at the beginning of the video?
Yeah, I observed a jump in video.
And that was about 42 minutes, correct?
Approximately, yes.
But now he's going to ask him, tell us about whether or not it was inverted when you first saw it, because when it was presented to the jury, when we, the public, saw it, it was inverted, a mirror image. It took the defense to point out that words that were written, for example, on the police car, a number on the wall, all of those things were backwards. And then at that point, the witness admitted that in fact it was inverted, and he just hadn't mentioned it at all at any point during the direct examination. So Trooper Proctor is going to tell us how it looked when he first saw it.
So the timestamp on the bottom was inversed? Was it reversed?
I beg your pardon?
Yeah, the timestamp on the
He's
on the
surprised.
bottom of it was it was backwards.
You saw at a timestamp that was inverted, correct?
Yes.
How about the video itself? Is that inverted? In your report, there is no.
So, oh, darn it. He said no, but I couldn't really hear it in there. It should have been in there. This was so critically important because what we had seen before was an inverted video, and one of the cues that the defense argued said that it had been doctored was the fact that the timestamp at the bottom looked normal, whereas the video was inverted. And they said that could only be done if somebody intentionally manipulated it. I don't know if that's true or not, but that's the argument that the defense was making. So Trooper Proctor is saying he saw it, and in fact, the timestamp was inverted, but the video was correct. That's how it was when the defense swapped it around and made it correct in the not reverse, not mirror image. And yet then the timestamp was backwards. The other way, when it was flipped, the timestamp was something you could read legibly. It was written in the right direction. So he saw a flipped version. So who flipped it? Who mirrored it before it was shown to the jury? That leaves a real serious question about what exactly happened. Could it have been some kind of just mistake by somebody? Of course, it absolutely could have been. But it's certainly weird that he saw a non-mirrored version and he saw the timestamp going in the wrong direction. That's what happened when it was flipped around by the defense. If you're kind of wondering what that looks like, on the Saturday night video, I showed what the jury was shown, and then I flipped it and showed what it would look like with the mirror image. That's also what the defense did on Monday when trial began again. But that's just, if you go back and look at that video from Saturday night, that's a sort of quick way to see the difference that I'm talking about. So now he is going to talk about some missing ring camera footage, because there are two really important videos that were missing. John O'Keefe had a ring camera, and some of those videos were present. We saw a picture of Karen Reed backing out of the garage and running into the John O'Keefe's car, which was parked in the driveway right behind her. She believes that's when and where her taillight got cracked, but that it was just a crack. It wasn't something significant or large. But there's some things that are missing. We have her backing out, but we don't have her coming in the night before. Well, obviously she must have come into the garage in order to back out of it, but that wasn't shown on the video. Even worse, we discovered that the troopers had actually had that video at some point, or at least it certainly sounded like they had. There was another video missing as well, from the next morning when Karen Reed's friends, Jennifer McCabe, now testifying against her, and Carrie Roberts said she pointed out to them the crack in her taillight. And there's no video of that either on the Ring camera footage.
No mention of the footage showing Karen Reed arriving home at 12:41 a.m., correct?
Correct.
And that's notwithstanding the fact that in Trooper DeChico's report, in his handwritten notes, he makes note of an event at 12:41 a.m. indicating, I think she arrived home, correct?
So,
Correct.
Trooper DeChico was asked by Trooper Proctor to review that Ring camera footage that they had collected. And he mentions, I see lights. I think she's coming home at 12:41. So he was actually seeing this. Why then is it missing when it comes time for evidence?
So sometime between when Trooper DeChico wrote his notes and when you wrote your report, that video footage vanished, correct?
There's also no date on Trooper DeChico's notes. We have many dates from Ring video, so I don't know if he's referencing a different date.
Well, you're aware that the video footage from 12:41 a.m. is gone, correct?
Yes, it's something I've tried to find through Ring for months, as well as the video when Miss Roberts, Miss McCabe, Miss Reed arrived back at John's and they're looking at the broken taillight. That video is gone as well.
Responded to.
So let me go ahead and preface this next section. It was, without question, the most serious thing that Trooper Proctor said in the text messages by far. And the cross-examination here right at the end, as Jackson is winding up his cross-examination, was just brutal. So I've left a lot of it in. I cut out just a bit kind of in the middle, but not too much, because I really thought you would want to hear exactly what it is that he said. It's very strong cross-examination.
A text message from your sister, correct? And your response was, hopefully she kills herself, correct?
Yes,
Who's she?
the defendant.
Miss Reed?
Correct.
You literally said that you hope that Karen Reed, the subject of your investigation, the woman sitting to my left, about 7 feet from me, that she would just die, correct?
The figure of speech.
You wanted her to, the figure of speech is you wanted her to kill herself,
No.
right?
No, it's not. My emotions got the best of me based on, the fact that Miss Reed hit Mr. O'Keefe with her.
Correct?
Correct.
Would you agree, Trooper Proctor, that you have dehumanized Karen Reed during the course of your investigation with comments and words like this?
Objection.
I'll give you this one, Mr. Jackson.
Would you agree with that?
I would say based off that language, yes.
Shame on you, sir.
Objection.
All right, so jurors, disregard that. I've told you before, lawyers can't make comments. They can ask questions. And Mr. Jackson, you know better than that.
So let me go ahead and pull this out. This would be a good time to go ahead and be putting questions in if you have any. And oops, meant to. Okay, so this would be a good time to put questions in. If you would, put question marks at the beginning. It'll be a lot easier for me to spot your questions if you do that. I do want to make a comment. His comment at the end, which was the title of my thumbnail, where he says, shame on you, sir. It was so it was so much the feeling that I think most people had. Certainly most of the jurors probably had that feeling that I had. I actually think he shouldn't have said it, not just because, not in any way really, because the judge said, oh, you weren't supposed to say that. More because it acted as a way for the jury to sort of let off steam, like, okay, yeah, somebody needed to tell him off. But I think he wanted the jury to stay pent up mad and to consider what he did to be the equivalent of what the Commonwealth did and what the Commonwealth's case is against Karen Reed. I don't think he wants to let them say, okay, well, that's Proctor, Trooper Proctor. He's in trouble. We're mad at him. But in fact, has the Commonwealth proven beyond a reasonable doubt that Karen Reed did this? So I did think that was a mistake because it kind of acted as a vow, but it certainly was something I think that a lot of people had to have been feeling. Because dang, and this goes with what Elaine G60 was saying. The detective has me angry, upset, and terrified. It's really astonishing the things that he said. It's really hard to believe that someone in such a power of authority and control made those kind of comments and seemed to think that it was okay until he was caught. And only then did it seem to be a problem. Matthew, thank you so much for gifting 20 Lawyerly memberships. That is wonderful. People have a lot of fun with that. Thank you so much. You get special emojis when you're a member, which are a lot of fun. We have a lot of fun using those. Praying for you. Thank you. The super sticker, I appreciate that very much. We have Celtic Moon is a new member, and CT Annie. Thank you so much for your super sticker. I really appreciate your nice comment too. We also had a couple of new members early on. We had Regina Durst and Jen Devka. So hopefully I have, oh wait, Darlene Daniels. That's great. We have a bunch. Okay. So, and now we've got two more, Pamela Lugo and Victoria Griffiths. Fantastic. Delighted to have all of you. So let's flip over and let's look at what some of the questions are. Going to back up a little bit, assuming y'all have had time to put in some questions. And hopefully I won't miss any. I don't know. It's hard to know how fast the chat is going. So, okay, I'm going to start with, there are a lot of questions in there. I'm not going to be able to answer all those, I don't think, but I'll answer as many as I can. Okay, Tennis Girl wants to know, is it common to take a police officer's personal cell phone? No, it is not common to take a police officer's personal cell phone. But I'm not sure what he was using for these communications or how exactly they came to be part of the record and part of what's being used here. Some of that came out, I believe, in the federal investigation, and then once it was revealed, then was available for use in the state one as well. Denise Pelton wants to know, when the prosecution rests, can the judge dismiss the case? Usually, yes. Here's kind of how it works. There would be a motion filed by the defense, and the defense would say, we believe there hasn't been sufficient evidence. We want you to dismiss the case entirely. And the judge will almost 100% of the time say, no, we're going to go forward and take it to the jury. We're going to let the jury make the decision. And that is 100% what the judge would say here as well. I think I just cannot imagine the judge dismissing the case, the charges against her at this point. I don't see that happening. So, okay, we've got Zana asking me, what was your opinion on how the text messages were presented? And I assume what Zana is asking me about is how the prosecution did it. I thought it was really critical that the prosecution get those out, because just as they really messed up by not getting some other items out early and letting the defense get to it. For example, if the prosecution had just said, isn't this video of the Sally Port inverted? And the witness had said, why, yes, it is. There would have been no cross-examination on any of that. It just would have been, okay, yes, so look at the far side, and we would have known about it. It was the fact that that wasn't something we heard about from the prosecution that opened it up for the defense to make such a major deal out of it. And I think that was part of the reason why the prosecution went ahead and got those text messages out there. They felt like they had to go ahead and do it. They probably should have done some more explanation around it. But the problem is, what is the explanation? And what possible excuse could there be for talking about someone's medical issues with people who aren't even police officers? It's really difficult to think of this. I'm sure that there'd be sort of a tendency to think, well, the prosecution has failed here. I really think Trooper Proctor's text messages were so explosive, it would be very difficult to minimize them. The prosecution can't just run away from these. These are really, really serious breaches of the trust placed in police officers. And so it just is what it is. And he's the lead detective. They did all they could to minimize it and put him at the end, but nonetheless, these are explosive. These are really serious ones. Kathy Johnson wants to know, did any of the people at the house go to John's memorial service? I don't know the answer to that. I wondered about whether Karen Reed did as well. I saw a picture of the coffin coming out, but I didn't see her there, and I don't know if she did or was allowed to or any of that. KML, how would Proctor have known of Reed's medical history? I wondered that as well. I don't know if she made some comment like, I'm sorry, I need a moment to go change or something. I don't know. He had not yet arrested her. So how did he know of that? Well, she was in the hospital that day. Could he have read the medical records? That certainly would be a violation too. I don't know how he found that out. Anna Banana wants to know, will we ever see any car black box evidence or solid proof one way or the other? I don't think we will. I think if there were black box evidence from the cars that showed anything relevant to the case, we would have seen that already. But the prosecution hasn't rested. So maybe there's some witness out there that we don't know about yet, Anna. We'll see. 22 SCHG wants to know, can they subpoena ring for the Alberts and neighbors' houses even though they claim they don't have it? Well, they could, but normally if there's no reason to believe that there's actually evidence there, then you can't get a court to give you some kind of search warrant or other reason to collect that evidence. So they don't have to turn it over unless there's something there, and if they say there's not there and you don't have any reason to believe otherwise, there's not really much you can argue with the court. Ted Guerin is asking me to do like a final poll, and that'd be a good idea as we get to the end. I usually try to reserve that and let people form their own opinion so we can kind of have a group that's open to whatever we think the truth is and whatever you think the truth is with the facts presented at trial. Kelly D, do you think cops do this more often than we know, or is this just one bad cop department state? I think both are true. I think, Kelly, that not many cops do this, but there are other instances that we don't know about. So I would say that both are true. It's rare, and this is not completely isolated. I certainly hope it's rare. Very, very rare. Jersey Jen. She has so many questions and wants to know directed verdict or mistrial. I don't see that. I don't see any reason, certainly no reason for a mistrial at this point. And directed verdict, I do not see that happening. Peanut Butter wants to know, did Lally ever get in trouble about not saying the video was mirrored? No, and I don't think he would unless we went through that in the video on Friday. I looked at what some of the statutes that would apply, actually professionalism rules that would apply to the lawyers and their conduct. And that would only be an issue if Proctor had some knowledge about what was happening. And there was really no evidence that and I don't know how there would be evidence that he knew, unless somebody comes up with evidence that he intentionally mirrored it and tried to trick the jury, which seems really, really unlikely. Then I don't picture that being an issue for him personally. It will, however, have consequences with the jury because it makes them not trust the prosecution. And I think that's very serious in trial if you lose the trust of the jury. Dan D, there's the nickel question. How much longer do you think is left on the trial before deliberations? The judge initially told the jury, you're going to get this case by the end of June. So don't worry, you're going to get this by the end of June. And then they started talking about new experts that the defense wanted. And the judge said, I can tell this is going to be a voir dire. There are going to be a lot of questions from the prosecution, and it's going to take longer. I'm afraid I won't get this to the jury in time. She was obviously worried about that. Now, the questions for the experts, the defense said, well, it's not really going to be that bad. We can do it pretty quickly. They can do it pretty quickly. This is questioning that takes place outside the presence of the jury, where the judge is going to make a decision. Is this expert someone that the jury is going to hear from or not? And the two sides will argue about it. Let me flip over here to see. I think I've got, another new member, Teresa Price. Welcome. Glad to have another new member. Okay, shouldn't this case be the basis of a general inquiry into the Massachusetts State Police? Eric London is wondering. Certainly that's already happened in Canton, because with the Canton police, there has been a movement within the city saying, we want an audit, an investigation of our police department, because we're concerned by the things that have been leaking out and that we're hearing. Now they're about to hear even more. Although, frankly, most of this relates not to the Canton police, but to the state police who were brought in to do the investigation when the Canton police were conflicted out. There's still plenty that's swirled around. For example, the vehicle, when it may or may not have had the taillight broken, was sitting in the Canton police garage, the Sally Port, they call it. Okay, Marvin wants to know, I know that Karen's on trial, but what are the chances of those who committed perjury going to trial? So, Marvin, it's really hard to prove perjury. You have to prove that someone knew that what they were saying was false. And so I'm not really sure which people you're talking about specifically. It is rare for there to be any kind of perjury charge in general, but certainly after a trial. But I don't know exactly who you're asking about, so I'm not totally sure how to answer that. Steve wants to know, is the attorney enjoying the witness being so awful? Is the attorney enjoying the witness? I'm not sure I followed that, Steve. Maybe put it in again. And I'm not sure if I understood what you were asking me. Jocelyn, a bad cop does not change the facts of the case, and that seemed to be his only defense. Do you agree? What is his defense? So I think what he's saying is, I may have made really big errors of judgment. He says the things I said were wildly inappropriate, and they were. Is there any questioning that at all? So he agrees with that. That's how improper they were. And his defense is, separate me from the case. I may be a terrible person, but if the facts are the facts, if she hit him, if she knocked him over, if she left him for dead to die in the cold, she's still guilty. So separate me from what you decide, guilt or innocence in this case. And that is correct legally, and that is pretty much his only defense as far as those text messages. He really didn't have anything to say except say over and over that they had been improper and not my finest moment. So Chris Showblock is asking me, Showblock, with all the objections with no reason and sustains with no reason, wouldn't an appellate court find that a problem? It'd certainly be hard to rule. And what Chris is referring to is the attorney, instead of saying even just one word like objection, hearsay, objection, irrelevant, just anything, says objection. And the judge says sustained or overruled. And that's all you get. There's no real back and forth discussion about it. So it's entirely possible that the judge is thinking, I am ruling based on this. And the lawyer is thinking, I'm objecting based on something entirely different. It can create a problem because the judge might be ruling on something thinking one thing and the lawyer meant something different. Well, on appeal, that does really mess up the record. It can make it more difficult. On the other hand, you could argue it gives the judge two bites at the apple, whether the objection was attorney-client privilege or irrelevance. Either way, that either one would be sustained on appeal if either one could be proven. So maybe it gives the judge two bites at the apple. It is unusual. I'm not used to that myself. Faye is saying the powerful true colors are showing, sending you love from Savannah. Thank you. I appreciate that. Savannah, gorgeous city. Absolutely gorgeous. Thank you, Faye. Okay, couple more questions. Let's see what we've got here. If this is best self, if people lied to the grand jury and investigators, can the prosecutor drop the case? Sure. The prosecutor could at any point say, I dropped the case. I believe that I no longer have in fact, I think the prosecutor would have a duty if the prosecutor believed there was no longer foundation for the case. I think the prosecutor would have a duty to drop it. If the prosecutor believed evidence had shown up, there was reason to believe someone else did it or that this person didn't do it, that's their responsibility. But I don't think that's going to happen here. I don't think that's how Lally feels. I think it's been investigated. And the arguments are what they are in terms of she was there. Her car has a cracked taillight. He was found lying in the snow not far from where her car had been. Numerous people saw her parked there. Numerous people say he didn't go into the house. So Those facts are what they are. The question is whether those were true facts and whether or not they were the only facts. Okay, I'm going to go with one more question here. I'm looking for a question. I'm looking for those question marks at the beginning. Remember, I got to see those. Okay. Janet wants to know, does anyone know if John O'Keefe's parents believe Karen Read did this, or do they believe it's a cover-up? I don't know. That would be super interesting. I would imagine that they believe that Karen Read did it. I believe since that was what, for years, the prosecution has believed, the theory that has been pursued, my guess would be that that is what they think and still think. But do they have some doubts based on what's come out? I don't know. I'd be very curious to know. Grandma of 3 wants to know, is Proctor still employed? The answer is yes. He said so. He testified so that he still works in the DA's office. He works in investigations and putting those together. Obviously, what's happening in this case could harm his credibility in other cases. Certainly, any defendant's lawyer is likely to say, hey, let's have all those text messages about my case too, because of the fact that they've turned up such good information for the defense. That's so damaging to the prosecution. So I would expect there to be more of that. We will be going live tomorrow night at 7 p.m. Be sure to hit the subscribe button so you'll get notice of that. If you would hit the like button for the video on your way out, it'll really help the video and I'd appreciate it. And I will see you tomorrow night at 7 p.m. That's Eastern time.